The member from Fredericton South, leader third of his party.
Thank you, Madam Chair, and good afternoon to everyone. So I want to start with let's see, Section 6 of the bill, Section 6.1, which essentially moves the responsibility for the Right to Information and Protection of Privacy Act to the Ombudsman. Now, the previous government had eliminated the independent position of a commissioner responsible for Right to Information and the Protection of Privacy Act, and passed that responsibility on to what became the Integrity Commissioner. And now this bill is proposing to once again move it, but continue to fold it in with an existing commissioner, in this case with the Ombudsman. So my question to start out with to the Minister, through you, Madam Chair, is why did the Minister decide to or propose to fold this responsibility in with an existing commissioner rather than returning it to a standalone commissioner's position?
So before I begin, I believe we left off with, I was asked to read in its entirety the Conflict of Interest Act. Can I clarify first that that won't be necessary?
That won't be necessary. I've read it, and I don't need you to read to me. Thank you, Madam Minister.
Thank you. I would have expected that from you. With respect to the question being asked by the member opposite, the decision was made based on reducing or keeping in check the number of legislative officers that we have, the roles of the current legislative officers, and the capacity of the current legislative officers.
There are a couple of things around capacity. Certainly, Justice Shen, when he had responsibility for this legislation, had taken it on himself to actually appeal one right of information request that had been denied by government, and he had investigated. Government still did not comply, so he took it on himself to go to court to appeal that, and did so successfully. Rather than requiring the individual who had made the original request to do so. If that approach is taken on by the Ombudsman, the philosophy of the Integrity Commissioner was, unfortunately, having watched me struggle before the court to appeal a decision of government or a department, and utilize the recommendations that the Integrity Commissioner had made as to why that information should be fully released. If this continues as a practice, do you believe that the Ombudsman will have sufficient resources to do so?
It is the intention that the same resources that were provided to the Integrity Commissioner would be available to the Ombudsman. So the intention is to have the same resources available.
The same resources may not be sufficient, through you, Madam Chair, if the Ombudsman took up this approach and routinely, or not routinely, but certainly from time to time decided to go to court and appeal a decision of a department. And that does speak to a related concern. Even when the responsibility for the Right to Information and Privacy Act was over with an independent commissioner, so a commissioner whose responsibility was largely for that, they were having to extend the wait times that they're supposed to be carrying out investigations in because of a long waiting list of requests for investigations by citizens who had been turned down in part or fully for information they've been seeking from government. So even then, there were inadequate resources to meet the timelines that are laid out to complete investigations on behalf of citizens by the Commissioner. So given the Ombuds's particular mandate he's got now, through you, Madam Chair, why does the Minister believe that he actually would have the capacity to ensure that those waiting times, those time frames that are set out for actually completing investigations would be met?
I thank the member opposite for that very important question. I think that it is a very important issue that we are cognizant of his concerns. That being said, the issue of resources will be one that is ongoing. As I'm sure the member opposite can appreciate, the number of responsibilities, of requests that will be made to the office are going to vary, and I would submit that we will have to constantly adjust, because we can't predict in any given year that this is going to be the workload. So we're going to have to continue to watch and to monitor to make sure that the appropriate resources are there and are available, because we want this to run as smoothly and efficiently as possible. But the member opposite, having more time in this House than I certainly have, is, I'm sure, more than aware that the issue of resources will actually fall to the Legislative Administrative Committee. And I suspect that if there is a need there, then that will be addressed and the appropriate resources provided.
The problem, through you, Madam Chair, the problem, though, of course, is the Ombudsman is one person who has a full plate as it is. The trends have been clear, unless they've changed in the last 18 months or so, that the workload has been increasing in terms of the demand for investigations, as the trend has been government being less willing to release information that people request about the business, the public business of government. So that concerns me when we have an ombudsman whose plate is full. So let me ask a related question, I guess. The Integrity Commissioner, of course, has always been a lawyer, as to my knowledge, and the Right to Information Commissioner before that was a lawyer. Does this, and I don't know the answer, but I'm assuming that the Ombudsman has never been required to be a lawyer, but maybe she can tell me whether that was true or not, is true or not.
First, I feel that there was actually a two-part question. Even though there was a question at the end, there was a great deal of commentary from the member opposite vis-a-vis a completely different issue, which was the resources. And I do not intend to speak for the Ombuds at all. However, I will assure the member opposite, through the chair, that there have been communications with the Ombuds vis-a-vis these changes of responsibilities. And the Ombuds is very much aware that if there is a need for resources, his ability to make those requests. Now, that being said, the question that was actually asked was in relation to the qualifications of the ombuds, and if there was a qualification that they had to be a lawyer. And I can confirm that there is no qualification. However, the ombuds is currently a lawyer. The current ombuds that we have does have that legal training, and I would submit that in their role making quasi-judicial decisions, it may be advantageous to have someone with legal experience in that position, but it is not a qualification.
Well, would the Minister and Attorney General agree with me, Madam Chair, through you, that if the responsibility for the Right to Information Act goes over to the Ombud, that a person in that position, that it will be necessarily become a requirement that they hold a law degree?
No.
So, Madam Speaker, that gets back to my concern that what I think was a wise and appropriate decision of former Judge Deschênes to start with the precedent of, or create the precedent of the Commissioner himself, in that case him going to court to appeal a decision of a department to refuse to act on recommendations that the Commissioner had made regarding a request for information, that if the Ombud is not required to be a lawyer, that that opportunity will be more difficult to pursue. I know lawyers, of course, work inside the what used to be the office of the Right to Information Commissioner, but it would, in my view, make it less likely that we would see the Ombud going to court on behalf of citizens to follow up on his or her recommendations for the release of information.
Would inhibit the ability to take something.
I appreciate the member's comments, and interestingly, he used a reference to trends, and not specifically in this context, but that's something that I'm always discussing, even in my role as a lawyer over the years. It's interesting because as we watch the legal practice evolve, and especially changes that we see in government, we see a movement away from the need to have lawyers. Particularly, I go back to my time spent at the Court of Queen's Bench, and what you see more and more is you do see more and more self-represented individuals, and you see people encouraged, in my opinion, to be able to represent themselves. Now, that being said, I'm going to get back to actually the question that is being asked. I think what is key in this situation is that the person who is hired is qualified. And I would also remind the member opposite that in this office, there is access to staff lawyers, and there will certainly be legal advice provided and available. I think what is key for us to remember is to make sure that we have a qualified person in this job.
Well, Madam Chair, through you, the point, though, is on self-representation, as Justice Deschênes concluded, is that form provided, the appeal process for being provided in the Act for going before the courts is not very effective if people are self-represented. And the idea, the spirit of the legislation from the very beginning was that the appeal process should be something that individual citizens can utilize effectively. And so just as a bit of a recap, if you're denied part or all of information request, you have two avenues for appeal. And the first one is you can go to the Right to Information Commissioner or whoever holds that role in this proposal, the Ombud, and request them to investigate. And they write a report based on their investigations to make recommendations. If the department still refuses to release the information or whatever information was withheld based on those recommendations, then the option still is there in the Act to go to court. And the intent of that from the outset was that it not be an arduous, expensive process, but a fairly straightforward process for citizens to do that. And judges have been quite accommodating, recognizing that, as I have been before the courts probably 5 times now on the right to information requests. However, as Judge Shane noted in his commentary around this before he retired in his role as Integrity Commissioner, we're in a situation where there are cases that it would be far better if there was someone arguing the case at appeal, and I'm talking about the statutory appeal here, not legal appeal, but the appeal process provided for in the Act that has legal qualifications. And again, it followed a case that I had been involved in that failed, and the judge actually used the part of her decision in the former case I'd failed at to support her decision in the follow-up case. So I'm done with that. Like I don't want to set any more bad precedents for anybody. And I was relieved to see Judge Deschênes take on a case himself, and it was successful. So that's why I believe, Madam Chair, that it is necessary, if this goes through, that the Ombudsman takes on this role, that that person actually be a lawyer, and that be a requirement of the post. So that said, I do want to shift to another part of the bill, and that bill is, that section is section 1(8), where section 11 of the Act is repealed and the following is substituted. So it substitutes a new section 11. In addition to advising a person of a determination made under subsection 10(2) or 2.1, the Commissioner may advise the person of any situation disclosed that in the Commissioner's opinion is a potential conflict of interest. So here we're talking about the Integrity Commissioner or the former Conflict of Interest Commissioner in matters of conflict of interest when they investigate. So my question to the Attorney General and Minister is why, since she was amending this, presenting this bill and essentially amending the relevant legislation here, that she didn't address the issue of perceived conflict of interest, which has been a hot topic in this legislature in the past.
Thank you very much, the member opposite, for that question. In fact, that is the exact same question that was asked here in the House yesterday, and I will answer it as I did yesterday, again today. That the purpose of what we're addressing today is only for the change of responsibilities. And as I indicated yesterday, and I will indicate again today, the Act has not had significant review since the 1970s. And so it is the intention of the government at this juncture to change the responsibilities, the roles of the Commissioner and the Ombuds by the moving of responsibilities for which the member opposite is very much familiar. And there are no substantive changes to the legislation being made, with the intention that government, upon these the changes that are before the House today, will then fully revisit the legislation for the substantive changes. And as also was said before the House yesterday, what is being requested, why the issue of perceived was not amended, is because it is the view of government that there would be significant discussion and involvement of stakeholders for the purpose of reviewing the Act in its entirety. That was not the purpose of what we're here for these changes, but it is the intention of government to move forward after the new commissioner is in place.
Thank you for that response. Through you, Madam Chair, well, repetition is how we learn, so I appreciate the answer that you gave being given again today. So I'm learning. And one of the things I'd like to learn from the Minister and Attorney General, Madam Chair, is then why Section 11 of the Conflict of Interest Act is repealed in this bill and then substituted with a new Section 11. Can she provide in detail exactly what Section 11 currently says under the Conflict of Interest Act and why new Section 11, she felt it necessary to repeal that and incorporate a new Section 11?
Thank you very much for that great question. If the member opposite recalls, the last bill that we dealt with was the Statute Law Amendments Act. And part of the reason why we did the Statute Law Amendments Act was to modernize legislation. And I would submit to the member opposite that the change that's being made in Section 11 is very much akin to the changes that were made in the Statute Law Amendments Act. So the previous reading of Section 11 made reference to the designated judge, and for the purpose of changing the roles, the wording had to be changed to reflect that it would be the commissioner, not designated judge. It is more of a housekeeping matter, so to speak.
Since I don't have the original act open, can the Minister just clarify for me then whether or not a potential conflict of interest appears in the current Section 11 of the Conflict of Interest Act as it does in this proposed amendment?
It does. Would the member opposite prefer that I read it to him?
No, that's quite all right.
It's short. It wouldn't take nearly as long as the conflicts, the whole act.
I'm good, thanks.
All right.
So we need to Kevin for the vote.
Okay.
So, Madam Chair, because I do think this is, I hear what the Minister and Attorney General is saying, but I think that this is an opportunity to address an issue that the Integrity Commissioner had raised in his examination of the case involving a former member of this House and what he talked about as a perceived conflict of interest. And so I think it's an opportune time to amend the bill number 30, with a very simple amendment to include perceived, so that part of the concerns gets addressed now and not at some later date. He was very clear on that. It's a common thing in a number of other jurisdictions. So right now, I will read Section 11 that's being proposed to replace the old Section 11. So what's being proposed that in addition to advising a person of a determination made under subsection 10(2) or 2.1, the Commissioner may advise the person of any situation disclosed that in the Commissioner's opinion it's a potential conflict of interest. So at this time, if this amendment I'm about to propose passed, it could easily read, in addition to advising a person of a determination made under subsection 10(2) or 2.1, the Commissioner may advise the person of any situation disclosed that in the Commissioner's opinion it is a potential or perceived conflict of interest, by adding simply that word. And so I feel that this is an opportunity we should take advantage of. The government likes to talk about acting, which is good. We do too. here at the Green Caucus, and so we want to see some action on this now, not later. So I move to amend Bill 30, Section 1, Subsection 8, Subsection 8, in Section 11 by adding the words "or perceived" after the word "potential."
Yes. I recognize the member of Fundy, St.
Sussex Fundy,
Martin's.
St. Martin's. We request a 5-minute break, so we just got this to take a look at this amendment, please.
Yes, we'll take a 5-minute break. So is there unanimous consent for 5-minute recess? Yes? Okay. committee reconvening. Il est proposé par le député de Fredericton Sud, leader de son parti, sur la loi concernant certaines responsabilités du commissaire à l'intégrité et de l'Ombudsman. L'amendement a apporté au projet de loi, article 1, paragraphe 8, à l'article 11, ajouter les mots « ou créer un conflit d'intérêt apparent » après le mot « intérêt ». Y a-t-il des questions ou des observations concernant l'amendement?
Okay, thank you, Madam Chair. And being new around here, I just thought I would ask a question about how we're going to proceed with amendments of this nature. It's coming from an opposition party, and usually in committee of the whole, you're asking questions about the bill and this and that. Just wondering, if we ask a question, could we ask a question of the person who made the amendment? Is that proper? Is that what happens? Or do we still ask the minister to respond and officials and then base whatever that response is on how to vote or whatever? So I'm looking for some guidance from the chair, and maybe the clerk could inform the chair what the best procedure is. Being new here, that's something that I would be interested in.
So in reply to the member, so the questions are directed through the minister to the staff, and it's not common practice that we would direct our questions directly to another member.
You may ask a member.
So of course the member who brought the amendment could certainly clarify some points or add comments. Thank you.
Thank you, Chair. So if I asked a question to the minister, from what I gather, the minister could answer based on reports and staff, and then whoever made the amendment may want to comment on the answer as well and ask a similar question. In answering that question, could make those comments to explain it then. Is that right?
Alors, pour s'assurer qu'on s'entende la procédure, c'est tout député peut se lever pour poser des questions par l'entremise de la ministre aux employés, et puis les autres, tous les députés ont le droit de se lever pour soit apporter une question ou des commentaires.
Merci, Madame la Présidente. So my question to the Minister, and I know the Minister is well versed in the law, and in fact is the keeper of law in the province, and I respect that totally. Just wondering if the Minister could sort of tell us and tell the Assembly here, what implication does the word, what does it mean to be perceived? Maybe give us an example and how that would appear in law with regards to our conflict of interest. Thank you.
Easy, easy, easy. Gentle, gentle. All right. We're talking to me. All right. Thank you very much to the member opposite for that very important question. I'm going to be cautious because I really at this point in time don't want to be construed in any way as providing legal advice, and so I'm sure the member opposite can appreciate the very fine line that I am going to travel here. So the question is a great question, and I'm glad that he's enjoying listening to my answer. So there's a few comments that I would like to make. So the question, the amendment is to add the word perceived. So it is a substantive change that is being requested. So I did a little looking around myself because I understand, when we're talking about substantive changes, that's a very big issue. Because the intention of the legislation before the House today was not to make substantive changes. And it's certainly my position, if substantive changes are going to be made, then it needs to be more than just a discussion of the very capable members in the House today, but that we should also engage in stakeholder discussions as well. It's something I feel very passionate about, that when we as government are making changes, that we don't just isolate ourselves to the conversations that we're having amongst the group that we have here, but we also engage the people on the ground. But so the question was perceived. I did a little looking into things myself, and I just want to reference that, first of all, interestingly enough, in the Black's Law Dictionary, potential is defined, perceived is not. So I had to go for a little more digging, and I resorted to the Oxford Dictionary. In the Oxford Dictionary, potential is defined as having the capacity to develop into something in the future. And that is the word that is actually used in the legislation right now, as opposed to perceived, which is defined in the Oxford Dictionary as to become aware or conscious. And so there is a much more subjective approach to perceived, which begs a much bigger question. If we're going to be talking about perceived, then in whose perception? Yes, we're thinking. Look, you and I we think alike. I love this. So that's why I have such concerns over making such a substantive change at this very time. It seems like it's only a small word, but as the member opposite, who I enjoy engaging with most regularly from your party, my critic, knows absolutely well, we've made a living on words. And words might seem like a very small thing, but they are actually incredibly important. Every word has significant importance, and it may seem like a very small thing to just throw in another word, but I would just caution the wisdom in that at this particular time, without deeper consultation, in particular, the Commissioner. And so it is for that very reason that we wanted to alter the role of the Commissioner so that the Commissioner could be engaged in those very substantive changes. The other thing I want to point out, a statement was made that perceived is used in many other jurisdictions. That I'd like to make that correction. In fact, it's only the Yukon that uses that term perceived in their legislation. And the other issue that I would like to point out is the amendment that is being made is only in relation to the Conflict of Interest Act, not to the Members' Conflict of Interest Act. And I think that that has been the primary concern in the past, is vis-a-vis the Members' Conflict of Interest. So I hope I've answered your question, and if not, then I would certainly welcome the opportunity to dig into it further to satisfy the member opposite.
Thank you, Minister. I think you've answered my question adequately. I appreciate the upfront information. So thank you very much.
I recognize a member from Fredericton South, Leader of his party.
Thank you, Madam Chair. Of course, Madam Chair, it is more difficult working on amendments in the committee of the whole, but that's the decision of this government to refer committee stage work to the committee of the whole rather than to a standing committee which could be given the mandate to call witnesses, where we could have witnesses before the committee, if it were a standing committee, if it were given the mandate by this legislature to do so, and then all members of that committee would have the benefit of the input, the testimony, the evidence provided by those witnesses. That's really what we should be, how we should be operating, Madam Chair, but the government chose to kick this over to the committee of the whole for bills instead of going to a standing committee as we've done for the last 4 years. Admittedly, that standing committee did not have the mandate given to it by the legislature to call witnesses, but the Premier earlier had given his commitment that that's exactly the way he would like to see the standing committees operate, have the ability to call witnesses, but we've yet to see a motion tabled in this House to enable that to happen from the government. So, Madam Speaker, we have what we have. We're working at committee stage, doing examination of bills in committee of the whole. And so that was a decision by government. That's what we're doing. And so we work with what we've got to work with, Madam Speaker. So, you know, the Judge Duchesne was very clear in his feeling that the important to include when talking about conflict of interest, give the ability of suggesting there could be a perceived conflict of interest to the Integrity Commissioner, and that's simply what this is proposing to follow through on. Thank you, Madam Speaker. Madam Chair.
Yes. Je reconnais le député de